Hello, everyone. Welcome to the Arbitration channel. Today, we're going to have another debate, what would be the arbitration in 2 words. This series is sponsored by Centro de Arbitragem e Mediação da Câmara Portuguesa, Quatro Casas, Encontro Internacional de Arbitragem de Coimbra, Moraes Leitão Advogados e Valde Advogados. We are thank you everyone for being here with us today. Be sure to subscribe the channel, please. I would also like to special thanks to Roseli Cândido Costa, who helped us to organize. And now I would give the floor from Luíza Kömel, who will be the moderator of today's debate. Luíza is Deputy Secretary General from the CAM-CCBC, Center of Arbitration and Mediation of the Chamber of Commerce Brazil-Canada, and Fellow of FCIArb. She has acted as counsel and case manager in domestic international arbitration proceedings and has extensive experience in international arbitration and mediation academic competitions. Hello, Luíza. Thank you so much to help us today.
Hi, Laura. Thank you. And also a big thanks to Arbitration Channel for the opportunity to be here today. Let me just start by mentioning our speakers. So Adriana Pucci is a leading practitioner specialized in commercial arbitration. She has advised clients and acted as arbitrator in arbitrations involving a series of industries and subjects, such as infrastructure engineering, construction, real estate incorporation, M&A, commercial agreements, and others. Adriana is regularly appointed as co-arbitrator, chairman, as well as sole arbitrator in proceedings conducted under the auspices of several arbitral institutions and ad hoc arbitrations. And on the German side, who is partner in Addleshaw Goddard's Hamburg office. He specializes in the litigation, international commercial arbitration, and investment arbitration. His most notable cases are successfully defending Croatia and Ukraine in a number of large ICSID proceedings. He was also part of a team that successfully settled Germany's longest and largest arbitration, representing Daimler Financial Services in connection with the German truck toll system. In addition, he works as arbitrator and mediator. Last but not least, Mr. Mauricio Gomm, who is a fellow of the Chartered Institute of Arbitrators, CEDR-accredited mediator, and a law professor. He's a partner at GST LLP, Miami offices, and his practice is predominantly as arbitrator, occasionally as mediator as well, in domestic and international commercial cases before leading arbitral institutions around the world. He's also proud to be one of the CAM-CCBC he was CAM-CCBC vice president between 2017 and 2019. So those introductions made, let me just state that today we're going to have a very dynamic debate. It's been over a year of these webinars, and I think most of us are tired of just watching people lecturing. So this is going to be a very dynamic panel. Please don't refrain from sending your questions. We will get to them either at the end of the session or during. I may ask the presenters some of those questions. Well, what we have here, we have 6 rounds of questions, and let me just go straight to the first one and start. It's regarding parties' expectations and local courts' parameters. Well, parties' expectations have certainly changed in the past few years. We have noticed, and now when I say we, I mention my institutional perspective. So we have noticed an increase in the amount of questions that are made by the parties to the arbitrators, even when there's an instrument such as a questionnaire or any other kind of instrument in which they can actually provide the information regarding their previous experience as arbitrators. So in this sense, do you see a change in parties' expectations on arbitrators' disclosure? And how about local courts? Do they require limited or an excessive disclosure? And let me just start by directing this question to Felix. Please, Felix, take it away.
Luíza, thank you very much, and thank you very much for the kind introduction, and also to the organizers for having me. It's a great honor. Disclosure, a relatively new thing in Germany, I would say. And in recent years, we've certainly seen an increase in expectation of disclosure, both from parties, arbitral institutions, as well as local courts. I think it varies also with simply more information being present regarding arbitrators and their party affiliations through modern social media or other activities and via the internet. It just has a more a larger audience, and that's why we've seen on all levels it's an increase of demand in disclosure. So that's the German perspective. Thank you.
Thank you. What about Mauricio? Could you give us, your impressions and what curious facts you have to bring from the United States perspective?
Okay, I echo, first of all, Felix's words, thanking the organizers, Arbitration Channel in CAM-CCBC, and you, Luíza, for being moderator, and Rosalie for putting us together to discuss this very important topic of duty to disclose, everything that relates to disclosure of a potential arbitrator. In my opinion, this was, has been, is, and always will be a hot topic. So it's not a question of only parties' expectations, but parties' anxiety. And the reason is simple, because we are talking about the first step of a decision maker who is going to know the case and is going to decide the case. So this debate, it was not by accident that this debate has led to some to advocate the need for the arbitral institutions to appoint all members of the tribunal. Whereas the predominantly view is that is the right of the parties to appoint his or her decision maker of his or her choosing. And this is considered to be one of the advantages, the main advantages of arbitration, especially in the international setting. So Luíza's questions, because there are 2 or 3 questions, so parties' expectations, role of the courts, and the scope of this disclosure from 3 jurisdictions, Germany, United States, and Brazil. So perhaps we have to ask ourselves here if we are not heading towards a sort of a disclosure paranoia. But in order to discuss this, or in trying to answer Luíza's question based on the USA perspective. So the United States, there is the Federal Arbitration Act, which dates mid-20s, almost 100 years ago. Section 10 of the FAA deals with grounds for vacating an award. Among those grounds, for the purpose of our discussions today, is whether there is an evident partiality. So the FAA says evident partiality, and this will show after the award has been rendered. So what happened before if there was an evident partiality? So the FAA itself does not provide for any standards of arbitrators' conduct prior to his or her appointment, as it is the case of, for example, Article 14 of the Brazilian Arbitration Act. That said, this question goes to what the case law says. Case law, arbitral institutions guidelines, and the professional organizations such as the IBA or ABA, so on and so forth. So case law, let me just, in that couple of minutes that I have, the pivotal case on this issue is a Supreme Court case back in 1968. And the name is Commonwealth Coatings against Continental Casualty. The substantive facts of the case are not relevant for the purpose of today's discussion. The key issue before the court in Commonwealth Coatings case was that the arbitrator had not disclosed past business relationships with one of the parties. By coincidence, the winning party, the victorious party. Then the question was, did such failure to disclose amount to Section 10 evident partiality? Here, we talk about a third. There was a panel of three. And the panel of three, we are talking about the presiding arbitrator. In a sort of a Young's parlance, is the neutral. Just bear in mind this word neutral, because back then, there was the wing arbitrators were not, especially on the commercial side, were not need to be impartial. There were wings, but the neutral arbitrator should be impartial. That's why we have still today this idea of being neutral, although today all members of the panel must be impartial, independent. So that case, because the lack of disclosure by that arbitrator, the neutral arbitrator, then the award was put before the court in a vacatur proceeding. And the district court refused to vacate the award. And the First Circuit, the Court of Appeals, affirmed the decision, meaning that's fine, the lack of disclosure, there was no problem at all. But then the case went to the Supreme Court. And the Supreme Court, based on Section 10 of the Federal Arbitration Act, reversed. And here are some of the lessons that we can take from Commonwealth Coating. Section 10 provides not merely for arbitration, but for impartial arbitration. The court used standards. Remember, we are in 1968, standards to judicial proceedings. If one party in a judicial proceeding can show that, unknown to him, a judge has had a prior relationship with the opposing counsel, there is no doubt that the judgment can be successfully challenged. A judge's decision should be set aside by the court when there is the slightest pecuniary interest on the part of the judge. And now, two parts of the opinion, and one is that Justice Black, who wrote the opinions for the court, state that Congress meaning the FAA, intend to guarantee the constitutional principle of judicial impartiality in arbitration proceeding. So, commercial arbitrators have a duty to disclose now any dealings that might create an impression of possible bias. Any dealings. Justice White, although concurrent with Justice Black, said because arbitrators are men of affairs and men of marketplace, etc., they should not be held to a standard of judicial decorum. Arbitrators should not be disqualified automatically by undisclosed relations that are trivial. But in this case, the relationship was substantial enough to warrant vacating the award. So here we have, although the same result, one is judicial decorum, any dealings must be disclosed, otherwise it opens the door for the vacatur. The other says, well, because the arbitrators are commercial people, not all of them, but only those that may lead to substantial relationship between the parties. That Commonwealth case in 1968, many cases came afterwards. I have no time to discuss those cases, but they discuss how Commonwealth Coatings should be interpreted by different courts. And today, there is a burden of proof, which is high, in order to prove that there was a substantial connection. Also, the reasonable person test. So what for a reasonable person should be slightest or an adequate relationship between the arbitrator and the parties. That is, in a nutshell, what I could say regarding this topic as far as the United States is concerned.
Thank you so much, Mauricio. Now, moving to Adriana. So Adriana, let me just go back and repeat the question for you. So do you see a change in parties' expectations on arbitrators' disclosure? And do you see also a change on local courts' expectations on that? So do these local courts require limited or an excessive disclosure? How does that impact on arbitration?
Thank you very much, Luisa. It's my pleasure to be here to share this morning with Felix, Mauricio, and Luisa. Thank you very much to Arbitra Channel and Roseli for putting together here. Well, this is the arbitrator's duty of disclosure. It's a hot topic in Brazil. We can say that it's a hot topic in Brazil. In order to understand how it works in Brazil, we need to have in mind three things. First of all, that the arbitration law states who can be appointed as an arbitrator under Brazilian law. And Article 13 states that any person with legal capacity and who holds parties' trust can be appointed as arbitrator. So this article is very important, and the issue that the arbitrator need to hold parties' trust is a very important. We need to take account these expressions of the law. The second thing that we need to have in mind is that the arbitrator duty of disclosure is provided by law. Article 14 of the arbitration law states that the person who has been appointed as arbitrator has the duty, before accepting the appointment, has the duty to disclose any fact that may raise concerns or doubts on her impartiality. So the duty of disclosure, the arbitrator duty of disclosure, is provided by law. And the third thing is that the arbitration law says nothing about how to identify those facts and circumstances that may raise concerns on the arbitration impartiality. So if we go now to the case law, we have two cases, Abengoa and Fazon, two cases that, in my opinion, these two cases, in my opinion, and I think in the opinion of the majority of the Brazilian arbitration community, those cases raise a red flag regarding the arbitration duty of disclosure. I'm going to mention these cases. What happened in Abengoa? Abengoa, the Brazilian Supreme Court denied the recognition and enforcement of two arbitral awards rendered in New York. Those were two arbitral awards because there were two arbitration proceedings, but those arbitrations were related and they have the same arbitral tribunal. I'm going to talk as only one case. So what happened here? The Brazilian Supreme Court denied the enforcement of these arbitral awards on the ground of evident partiality of the chair of the arbitral tribunal. What happened? The presiding arbitrator, the chair of the arbitral tribunal, failed to disclose that his law firm was providing legal advice in a number of matters involving one of the parties of the arbitration, the winning party. The point here is that the chair, the arbitrator, he declared that he didn't know, he wasn't aware about the existence of that conflict of interest during the arbitration's proceedings. But the Brazilian Supreme Court, in my opinion, applied an objective test, and the Supreme Court decided that the conflict of interest existed. There were a lot of evidence that that the law firm was providing legal services to one of the parties, and that was sufficient for the Supreme Court to understand that the chair of the arbitral tribunal was wasn't impartial, or at least he was biased. This case happens in 2017. Then we have another case, Fazon case. I think it was 2020, last year. That this case, the São Paulo State Court went one step further. What happened in this case? Fazon arbitration, the presiding arbitrator was appointed by one of the parties to a second arbitration, and the presiding arbitrator didn't. He fails to disclose this new fact, and the São Paulo State Court understood that the failure to disclose was sufficient in order to set aside the award. The failure to disclose was a ground to setting aside the award, because the court understood that the arbitrator breached the party's truth. That it's mentioned in Article 13 of the arbitration law. So what happened today, in my opinion, and in the opinion of I think of the arbitral community here in Brazil, it is necessary to clarify what is the extension of the duty of disclosure of the arbitrator, because this Fazon case applied a subjective test, and this case, which is uncertain and caused a great concern to the arbitration community. And again, I must say that it is necessary here, in my opinion, in Brazil, it is necessary nowadays to clarify which is the nature of the arbitration's disclosure. Well, this is maybe then we can discuss those cases before, after. Thank you.
Thank you, Adriana. So now that the speakers are warmed up and Adriana gave us a sneak peek on the cases we plan to discuss here, let us go straight to a controversial topic. And the second round is about multiple appointments and consequences of non-disclosure. So I think that I will pose the question to Felix first. Is the failure to disclose itself a reason to remove an arbitrator? So Felix, if you could give us the German perspective on this question, and also mention case law in that regard.
Yes, I'm certainly very happy to do so, and I'm hopefully will be able to draw from what Mauricio and Adriana already told us. I mean, in general, with disclosure, we always have to distinguish between three phases of the arbitration. The beginning, the formation of the tribunal, then the ongoing arbitration, and then after the award is rendered. So from a German perspective, the duty to disclose, of course, extends to the first phase, but the arbitrators also have an ongoing duty to disclose if facts materialize during the arbitration. In those two phases, the remedies that the party has is to challenge the arbitrator. And then, of course, if the challenge is not upheld by the arbitral tribunal or by the arbitral institution, whoever is responsible, there's a possibility to have the court decide on that. after the arbitral award is rendered, you can't challenge the arbitrator anymore because he's no longer in office. So, and then the question turns to the point that Mauricio and Adriana already alluded to. Is there a possibility to challenge the award itself on the basis that the tribunal was not properly constituted because one of the arbitrators was biased? And that's where disclosure comes in. And in particular, multiple appointments play a very diverging role, or very important role, and we've seen really different decisions over the past. In Germany, there's no jurisprudence on that issue in general, but German courts have held very strict disclosure requirements, even during the arbitration. And once the arbitration is concluded, have said, well, this disclosure obligation does not exist anymore, but the parties can challenge the arbitral award. But the standard there is the same as during the arbitration, only if the facts that were supposed to be disclosed are sufficient enough to give justifiable doubts as to the impartiality or the independence of the arbitrator. And in Germany, in that respect, follows the UNCITRAL model law and the objective standard that's used there. So, and there are two cases I'd like to talk about. One is a famous German arbitrator who was appointed on an ICC tribunal, and by the same party also on a parallel ICSID tribunal. So ICSID was the investor-state arbitration, and the ICC was the commercial arbitration. And he was then subsequently challenged before the ICSID. And ICSID held that his two appointments represent grounds for a challenge because he could learn something in one arbitration that he is only privy to, and then use that in the other arbitration, and that party in the other arbitration, because they're not in that arbitration, and would be disadvantaged. So the ICC upheld that, which I found a surprising decision because, as Mauricio said, one of the tenets of arbitration is you can choose your own arbitrator. And if I have parallel arbitrations, I, of course, have a vital interest in having the same arbitrator so we don't come out with conflicting decisions. But that's how the ICC decided that. And then, as I said, in Germany, generally, if you don't disclose something, that's not sufficient by itself. And that was a recent decision rendered by the Federal Court of Justice in 2017. So, and very interestingly, the British Supreme Court was faced with a very similar question in the Halliburton with this Chubb's case. It's a series of arbitrations that stem from the Deepwater Horizon economic catastrophe in the Mexican Gulf. An arbitrator in the first case was appointed as the chairman by the court after the application for a party to do so, and then later was also appointed in other arbitration cases. The party found out during the arbitration and said the arbitrator should be removed. So they challenged them and should be removed by the court because first he failed to disclose, and second, there's justifiable doubts for reasons to believe he's impartial or he's not impartial or independent because he's privy to information from the other arbitrations. And the Court of Appeals initially held that there's not sufficient ground to disqualify the arbitrator, and simply said, well, there wasn't even sufficient grounds for disclosure. And then the Supreme Court held that, yes, the arbitrator should have disclosed these facts because they're potentially relevant. So basically, the level of challenge is here and the level of disclosure is lower than that. And that mirrors what German courts have held. So he should have disclosed. And then the Supreme Court looked at whether the facts that he should have disclosed were sufficient to rise to the bar of a successful challenge. And they said, no, because it's parallel proceedings. The arbitrator, well, may be privy to certain information from one arbitration and the other, but they believe that he's sufficiently professional to be able to distinguish between these information, and only then be able to provide base his decision on the information he received in the respective arbitration. So it's quite interesting. We have German and British courts that basically say we have a lower threshold for disclosure and then a higher threshold for the challenge. And the fact that you didn't disclose doesn't really affect, doesn't elevate the facts for disclosure to a challenge. But at the same time, they held in these respective cases that it's not sufficient for a challenge. Whereas the ICC, in a very similar setting, said, well, if there are parallel proceedings and arbitrator is sitting on a number of panels in these, that does disqualify them. So it's a very interesting development. I'm very interested to hear what my co-panelists think about that.
Thank you. Let us go straight to Mauricio. Mauricio, what's your take on that?
Okay, thank you, Luíza. This issue of multiple appointments leads us to think a little bit, just to make one step back. Why today there are multiple appointments? Probably because this is a result of an explosion of arbitration around the world. And as Adriana said, especially in Brazil, so more quantity of cases, but perhaps the number of arbitrators, the arbitrator community, if I may say so, remains relatively small or not as big as the amount of cases. Then we start seeing, as we have seen, multiple appointments. Multiple appointments, we have to first think a little bit of if the parties are the same, if counsel are the same. Does this matter if counsel is the same? Parties are the same. Subject matter of the cases, stages where the cases, the 2 cases or 3 cases, are evidence produced in those cases, etc. So it is, I would say, it's not a red flag. It is a yellow flag that the potential arbitrator has to think first what may be, in the eyes of the parties, some sort of issue that may break what Adriana was saying, that break the confidence or break the trust of the parties. But failure to disclose does not necessarily, automatically, as Felix was saying, to vacatur or set aside the award later on. So this is my some reflection, some thoughts about multiple appointments. Now, when Luíza was asking, failure to disclose itself, is it a reason to remove an arbitrator? Felix I agree entirely. Those 3 stages, the duty to disclose and the ongoing duty once the proceeding is on its course. Here, and Adriana was mentioning the Abengoa case. Abengoa case is a case that has brought a lot of discussion in the international community because there are 2 conflicting decisions, if we may say so, before the New York courts and the Brazilian courts. This is a case, the seat of arbitration was New York. Therefore, the primary jurisdiction to hear requests for annulment is New York. This is basic principle that everybody knows. And here, when we go a little bit further of what happened in the Abengoa case, first there is a cultural difference between U.S. and Brazil, and then we can talk about the legal aspects. But there is a cultural difference. And here, as Adriana was saying, so the presiding arbitrator didn't disclose relationship that his law firm or the colleagues of his law firm had with one of the parties in other issues, other transactions. So the losing party tried to avoid confirmation of this award before New York courts, whereas the winning party sought to confirm the award. And then we went to the issue of subjective impartiality. And in the US, the arbitrator was invited to testify whether he knew of these facts. It's not just an objective test. No, I want to know, although you failed to disclose, that's for me, said the courts. That is clear. There was a failure to disclose. You should have disclosed. You have, your law firm, big law firm, etc. You have means to do, a decent conflict checking. So, but the mere fact that there was no disclose, the question then is, did you know in order to reach a conclusion whether there was a partiality or bias, etc., etc.? And it's typical in law firm here to create sort of a Chinese wall, and you don't know anything that may happen across the door in your in other case, etc. And that was the case. And the courts in New York was satisfied after having heard the arbitrator himself that he did not know about those facts. Therefore, the court just refused to set the award aside and confirm the award. Now, there is this discussion between what happened in Brazil, so Adriana has mentioned that, and I'm not going to enter into details. But the test here, again, went back to the section 10 of the FAA, the evident partiality, and the reasonable person, according to the court here, was if the arbitrator did not know and the court was convinced about that such lack of knowledge, then the court confirmed the award. And there is one passage here that I'd like to read by the Second Circuit that says, quote, "We have repeatedly cautioned that we are not quick to set aside the award, to set aside the results of an arbitration because of an arbitrator's alleged failure to disclose information." So just bear in mind that expression, we are not quick to set aside the award. In other words, please don't come to me as a judge with just one single isolated issue related to lack of disclosure that we are going to set aside. No, we are not quick. We are going to review the circumstances under which such lack of disclosure happened, and then we are going to decide whether this warrant annulment or not.
Thank you, Mauricio. Now let's go back to Adriana. I think she'd like to say a few more words regarding the Fazon case.
Okay, thank you very much. This is very interesting. Abengoa case is a very interesting case. We can stay hours talking about that because I think Mauricio raised a point. It's a cultural matter also, not only legal, but also cultural. There are many cultural issues involved. But again, as I mentioned before, Fazon case, I want to stress that it's not clear in Sao Paulo State Court decision if both arbitrations were parallel arbitrations. One of the parties raised that yes, there was a certain relationship. The arbitrations were related arbitration, but the presiding arbitrator state that know that both arbitrations were different, and the matters of the arbitrations were different. They were not related arbitrations, and also the law firm who appointed him in the second arbitration was different of the law firm who represented the party in the first in Fazon arbitration. But what provoked concerns is that the Sao Paulo State Court didn't discuss this. If you read the decision, it's not clear if both cases were related or not, because the decision of the Sao Paulo Court was that the failure to the closure was itself a ground for setting aside the award. That is why, in my opinion, this case is very important and provoke many concerns, a great concern in the arbitration community here in Brazil, and that's why it is necessary. I repeat, it is necessary in Brazil to clarify the extension or the nature of the arbitration's duty of disclosure. Thank you very much.
Thank you, Adriana. So now let's move on to the next round. And in the next round, we would like to discuss soft law and international guidelines. So the IBA Guidelines on Conflict of Interest is a valuable resource. It is largely used for guidance and often referred to in decisions on challenges of arbitrators. However, there are still many who resist applying the parameters set by the IBA, arguing that local markets and cultural differences require adjustments on international standards. So my question to you is, what should one resort to when assessing what to disclose if there's no consensus regarding the specific circumstances which should be disclosed? So who wants to go first? Because we just heard about Adriana, so maybe Felix could go first.
Yes, certainly. Thank you. So I think as a lawyer, I would always say, please err on the side of caution. So if I get chosen as an arbitrator and I'm considering whether there are points that I want to disclose or not, I would always disclose more than less. Just because there are different levels, and it's easier to disclose something up front and then have a challenge come if may, and deal with it than having the risk of having the award set aside later on. I don't want to expose the parties that appointed me in an arbitration to that risk. Therefore, I would always say better disclose more than less. In particular, with the IBA rules, they set guidelines, but they still have room to maneuver. I mean, there's the green list, there's an orange list, and then there's red list and waivable and non-waivable red list. So I think it's always important to disclose even what's on the orange list, just to bring it out in the open and allow discussion on that. And German courts, they have looked at the IBA guidelines, and they've taken them into account when deciding on the standard of disclosure and also on potential challenges. But they always said they provide persuasive precedent or guidelines, but they don't provide help or they don't decide the individual case. So they always say, German courts, we have to look at the individual case and the individual circumstances. So one example was where they believed disclosure was warranted, where two partners worked together in the same office of a law firm in the same practice area for a long time, and then 15 years later met each other again in an arbitration as party counsel and arbitrator. And they said, the court said, it's important to disclose these connections, even though, as you all know, 3 years is the rule provided in the orange list of the IBA guidelines. And we're now talking about 15 years. But they said, well, you need to disclose anyway, because they work so closely together that it is important to know whether from that past business relationship, there are other ongoing business relationships or even friendships that need to be taken into account when considering the overall situation. So that's the approach German courts are taking. But I'm really interested to hear about the cultural differences and in perceptions that Adriana and Mauricio were alluding to.
Yes, let's go to Adriana then.
So thank you very much. Here in Brazil, the IBA rules, we use the IBA rules. As Felix mentioned, the courts didn't use those rules in their as a rule, as a hard law, because they are soft law, but they are tools of rules that we can handle, we can use, or the arbitrators can use in order to make their disclosure. But the point is that nowadays in Brazil, after Fazon case, I think the thing to do, as Felix said, is better to disclose. Better to disclose. You know, we need to use use this recommendation, the old recommendation, that when the arbitrator has doubt of disclose a fact, if he has any doubt, it's better to disclose, because that's guarantee that the arbitral award I don't know if it's guarantee, but helps that a court don't set aside the award.
Thank you, Adriana. So finally, Mauricio, what do you have to say about that?
Yeah, your question, Luíza, was what should one resort to when assessing what to disclose if there is no consensus? What to resort to? First, I think that one should resort to his own mindset. This is a matter of initial common sense. Once I read a sentence when I was traveling, I think one of my multiple trips to Brazil, when I read on the plane, a sentence that says, a person is really ready for life when his or her mind becomes his or her best friend. So you have to see yourself and place yourself in the shoes of the parties. That is, to me, that is the first analysis, a more internal analysis. Then we go to other criteria, such as, is it a domestic arbitration? Is it an international arbitration? And then goes to the cultural issue that Felix was alluding to. In domestic arbitration or in domestic setting, perhaps some relationships, some contacts, some maybe normal or maybe abnormal, in a sense that the courts may see this in a different way. If you are an international case, then you are in a different seat, probably a seat, different arbitrators, and different criteria based on the courts of the seat. And then the arbitrator, the potential arbitrator, has also to bear in mind code of ethics, arbitral institutions, guidelines, and so on and so forth. In the United States, and specifically in one of the arbitral institutions, there is a recommendation, which is the AAA, the ICDR. There is a recommendation that if you are in doubt, disclose. You don't even have to go to IBA Guidelines. They even suggest that you avoid or not pay too much attention on those colorful lists of the IBA guidelines. Just disclose, disclose, disclose. Here is a very, I would say, a very proactive position of the AAA and ICDR. The risk or the flip side of the coin is, do we have to review just about everything? And are we going to create a sort of an industry of objections and challenges because we are disclosing everything and create some rooms for delays, maneuvers, frivolous challenges, etc. So I don't see the courts do not have a clear, a black and white decision or direction. It is fact basis, but there are some indications, such as this one of the ICDR.
Great. If I may, Mauricio, I think that your comments made me think of a follow-up question. So you mentioned that the arbitrators should resort to their own mindset. But what about the concept of the eyes of the parties, which have recently become more of a controversial? It used to be just a consensus in arbitration. Now it's more of a controversial aspect. What do you guys think about this eye of the parties test?
Shall we start?
You may.
Okay. I don't want to monopolize. When I said the first, when I said the first analysis is owns analysis, I didn't mean to say that's the most important one or that's the only one. That is just the first one. And of course, this includes also putting yourself in the shoes of the parties, and then comes the expression in the eyes of the parties. And so you have to bear in mind what is important, what is relevant, what is key for the parties to be disclosed. But again, this is an open question, because we don't know how far shall we go. How far do we? So today, this issue of being together in a Facebook or LinkedIn or etc. So this does not create any ground for challenge, but we may just go cite examples after examples. So I think this is a kind of question, Luíza, that invites us to reflect, but not to answer in black and white mode.
Thank you, Mauricio. Felix, I also have a follow-up question for you. So you've mentioned that one should disclose more than less. And also Mauricio then mentioned that if you are in doubt, disclose, disclose, disclose. However, in many arbitrators place themselves in a more passive position in which they disclose only what is strictly obvious, and then they leave room for parties to ask whichever information they wish to know further. And well, some phenomenon that we've noticed more recently is there more seasoned arbitrators, so the more experienced ones, they tend to disclose less than younger arbitrators. So arbitrators who have just started and recently taking cases as arbitrators, they tend to disclose a lot more, even though generally they have less experience than the more seasoned ones. So do you have a perspective on that? What is your opinion on that?
Thank you for the question. It's really interesting. I think it's part of the limit that human capabilities pose upon us. As a young arbitrator, you've limited cases, so they're all very present. You know how many publications you made. There are probably a handful. So you'd be able to disclose that. But imagine an arbitrator who's gone through 20 or 25 years of experience, and besides sitting as an arbitrator, has acted as counsel, maybe as a legal expert here and there, and sometimes even had just very ancillary roles in the arbitration. And he won't remember everything. And unless he has an impeccable case record that he established over time, he's really no possibility to disclose everything. And I simply agree that there's a time limit on everything. So even more seasoned arbitrators should just disclose what's really relevant. And I think I understand it very well. As a young arbitrator, you want to be perfect on everything, and that's why you disclose more, and that's perfectly understandable. But I don't think it's always necessary.
Thank you, Felix. Yeah. So and the final question on this round would be that recently the draft code of conduct for ISDS adjudicators, which was developed by the Secretariats of Unstral and ICSID, was heavily criticized for its broad disclosure obligations, such as the duty to disclose a list of all publications by the adjudicator candidate. Of course, this is for investment arbitration, but Adriana, do you think that this could be a trend for commercial arbitration? That the arbitrators have to disclose a list of all publications?
No, I don't think that this will be a trend, because as Mauricio and Felix mentioned, I think the arbitrator has to disclose the relevant things. You cannot agree. We cannot agree with disclosure paranoia. You know, we have a limit of time. We have because, as you mentioned, we are getting older and we have more experience and more relationship with parties and lawyers and counsels. So I think that I hope that this will not be the trend, because we need to keep we need to find an equilibrium. So, and we need to find which is the point, which are the relevant things that the arbitrator should disclose. And I don't think that those kind of tools, those kind of set of rules can substitute the set of mind, the set mind of the arbitrator. It's still very important that the arbitrator disclose what is relevant to him, and what is relevant to him, and what is relevant to him thinking on the parties' interest also. But I don't think that this would be a trend, you know.
Thank you. Okay, so now to the fourth round. We have also a very controversial question for you. It's regarding double heading. So double heading happens when, for instance, an arbitrator appears as counsel before tribunals composed of arbitrators with whom he or she had previously sat. And how is it that the practice of double heading can affect the arbitrator's impartiality? Furthermore, what should arbitrators do in order to avoid a double heading situation from rendering an arbitral award vulnerable or susceptible to annulment? If Felix could please start on this matter.
Thank you. I think double heading is a very interesting question. And we see the same term used in different areas. In investment arbitration, for example, double heading describes just in general acting as an arbitrator and acting as counsel. And the new rules or suggestions, Luíza, actually are very critical about double heading. where I think it's very helpful for a counsel to act as an arbitrator, and for an arbitrator to act as a counsel, just to see the different perspective and be able to experience different roles and learn from that and grow in their experience. But your concrete case, where I think disclosure is very important, and I'm very wary of double heading, and I remember very well a large investment arbitration where the other side suggested a chairman, and then through our research we found out that that chairman is sitting with counsel from the other side on a number of arbitral tribunals, actively sitting and recently sat, and that's why we didn't agree with that appointment. I don't think it would have been sufficient to raise a challenge, because I believe arbitrators are sufficiently professional to be able to distinguish between their roles. But it does leave some taste of unnecessary familiarity between the arbitrator and the counsel. But as Mauricio already mentioned earlier, it's just a fact that the arbitration community is a small world. It's enlarging, but it's still a very small world. And the fact that you know somebody from another arbitral tribunal, that you know somebody because you, like us, are sitting on a panel together, should not be able to give rise to a challenge from an arbitrator, because it's really no conflict of interest. It just happens to be active in the same area of professionalism.
So you don't think that it affects their impartiality? So no bias, nothing could be directly derived from them? Because, well, and now saying from my experience, I've actually, as the institution, we've received calls from sometimes lawyers or directly from the parties stating that this does cause some kind of discomfort for the parties. So I know that for us, for people who are used to the discussions, either in investment arbitration or in commercial arbitration, this is a more acceptable practice. However, we still see that many parties and lawyers, I mean, counsel representing parties, are still quite uncomfortable with these double headings. So I don't know. I think that if not something that should be disregarded entirely, but it should definitely be taken into account for an arbitrator when taking either one or the other case, so that they know that the parties sometimes are uncomfortable, even if that doesn't lead to an actual challenge, as you pointed out. But now, oh, sorry about that.
And that's why I think it's really important to disclose that. It's the same what we have in England. Barristers, they work together in a chamber, but they're really single practitioners. So you very often have barristers act as counsel and have barristers sit basically as arbitrators, and they're from the same chambers. And if you don't know the culture behind barristers and how they're independent, and for example, because you're from Brazil or the United States of America or Germany for that matter, you think there's something fishy going on, what's happening? But if you disclose that beforehand and saying, well, we'll be acting as counsel, barristers from the same chamber as an arbitrator, but this is how our chamber worked. We're independent professionals. We just share the same mail service. Then it's more acceptable. That's why I think disclosure can actually bridge a lot of these cultural differences that we see in the world of arbitration, and also vis-a-vis the clients.
Yeah, sure, I agree. As long as you disclose it, then, well, at least the parties will have the opportunity to assess that information. Mauricio, you would like to make comments?
Yes, yes. This notion of double heading, Felix has already. So I was thinking about this before. So double heading is being counsel and arbitrator, being arbitrator and mediator. It's very, very. It's a completely different hat. So here, your question is a little bit deeper, because it creates, as you properly said, Luíza, discomfort. If we are in a hearing, and Luíza, you are the leading counsel of the opposing party, and I am counsel for the other party, and I learn that you, in another case, you are sitting as co-arbitrator with Felix and Adriana, and Felix or Adriana is also sitting as arbitrator here. So the fact that you have this relationship, professional relationship, you name it, with one of the arbitrators, and I do not have, this creates at least a discomfort that should be subject to disclosure. However, the mere fact that there is this uncomfortable situation, in my opinion, per se, does not lead to challenge, etc. However, if this one, together with other issues that may happen in the proceedings, in the course of the proceedings, denial of one specific evidence, whatever. So then you can, at the end of the day, you may, at least this scenario can create a circumstance, a situation where the award may be subject to set aside. I'm not saying that it will be, but maybe. But again, the mere fact that there was this double heading, you, for example, in my example, I can say, well, I know this arbitrator, I know you, etc. So I know, although you are represent the opposing party here, I know that you are very serious, professional, and the case that you are sitting as arbitrator is completely different from this one. So I may be satisfied. Even if I am not satisfied, again, I insist on this, this does not create, per se, isolated circumstances, room for setting aside. Coming back to Felix's point, that's why it is advisable to disclose upfront. Now, if I may, if possible, Luis, if I may come to the other question, because I had raised my hand to just a very quick comment on the other question regarding the exceed in the list of all publications. I think it makes sense to make some sense that this list of publications by the candidate be encouraged, because exceed, we all know, they are all public cases. And perhaps it is important, or may be important, for a party to know exactly what the candidate has written about the topic. I agree with Adriana. I don't think this is going to be a rule or a trend in commercial arbitration. But here again, even in commercial arbitration, if the party thinks that the potential arbitrator has a massive amount of writings, or even some writings, it doesn't harm to ask questions in the first step to the arbitration, to the potential arbitrator about his writings. Of course, the question cannot go straight to the merits of the case, but in general terms, the party can get what the party may get in a more compelling disclosure based on this exceed scenario.
Thank you, Mauricio. So I think that it is the general consensus that is between Felix and Mauricio that the situation should be at least disclosed. And on that, I have a follow-up question to Adriana. So Adriana, considering that these situations should be disclosed, and considering that double heading situations tend to lead to a reduction in professionals acting as arbitrators, not only double heading is something that makes the parties uncomfortable, but also may lead to a concentration of the professionals acting in arbitration. which would automatically lead to a lack of diversity in arbitration. So what is your position on that?
Thank you, Luíza. Well, first of all, I'm not sure if I am agree with Mauricio when it says that when the arbitrator and counsel of one of the parties have previously served together as arbitrator, if the arbitrator needs to disclose the situation. Maybe the arbitrator can disclose, but I don't think that is well, maybe I thinking about Brazilian community that we know each other, that is a small community. So I don't think that the arbitrator needs to disclose that he served before as an arbitrator in another arbitral panel with the lawyer of one of the parties or the counsel of one of the parties. I think that the point in the double hatching practice is when the counsel, as arbitrator, as a judge, need to decide a matter or need to how can I say, need to refuse or confirm a matter that he is defending in another arbitration as a counsel. So this point is very serious, in my opinion. See, when a counsel is defending an argument in an arbitration, and then he is appointed as in a second arbitration as an arbitrator, where he will decide the same matter, where he has to decide the same matter. This is the matter that he's defending in the first arbitration as a counsel. This is very serious. I think in this case, the arbitrator or the candidate to be an arbitrator must have to disclose to the parties.
Okay, Mauricio, do you wish to make any follow-up comments on that? Or
Thank you. Well, first of all, I love the discussions and debates because with different opinions, we all learn a lot. But I think that we do not have a completely different opinion here. I just want to clarify one aspect here. I didn't say previous cases. What I meant was concurrent cases. So when in my example, Luíza is an opposing counsel, and Luíza in an ongoing case, and Luíza in a separate ongoing case, not previous case, is sitting together with one of the arbitrators. I think this is a yellow light. This is something that must be taken into account in order to raise the level of comfort, level of trust, level of confidence of the parties. And perhaps depending on, again, cultural issues, again, domestic vis-a-vis international. If in the case of Luíza, for example, Luíza is a well-known person in Brazil, well-known arbitrator, so she is extremely well-respected. So maybe it doesn't matter if she is sitting together with one of the arbitrators in another case. It doesn't matter. But maybe we can't say that everybody that sits in the other side of the table as opposing counsel is as decent, as serious, as ethical, as competent as Luíza is. So that situation, to me, would invite further thought of the person to disclose.
Thank you, Mauricio. Adriana, would you like to make some final remarks?
Well, another thing that I would like to mention is that this double hatting practice goes against to, or not goes against, it's doesn't help to have more diversity in our arbitration panels. So this is an issue that I think that we need to continue talking about this practice. We need to have more discussion about how less comfortable are the parties with this practice, not only in order to have not only to have a more transparency in the arbitrator's disclosure, but also in order to help to have more diversity in the arbitral tribunals.
Thank you. So far we've been focusing on what the arbitrators should disclose or should not disclose. And now on this next round, I'd like to move to parties' duties. So Felix, what do you think? The arbitrator's duty of disclosure is much discussed, but what are the parties required to disclose in an arbitration proceeding?
Well, my opinion, and that's backed by the German jurisprudence, is that the parties actually have no disclosure obligation. The parties are not obliged to be neutral or impartial. On the contrary, in particular, the counsel, they're representing their party in an arbitration. So they have no disclosure obligations. It's really entirely upon the neutral, be it arbitrators or experts for that matter, to disclose that. And I want to use the opportunity to reiterate Adriana's point. I think it's double heading in the discussion that comes for it. With it is severely limiting the arbitrator pool, and we already have a very limited pool. And I need to take a stance here for all the young aspiring arbitration practitioners. You originally start or always start as counsel in arbitration, and there you impress your peers, and then one day they decide that you move basically from counsel to arbitrator as well. And if we were to limit that through double heading, that would severely limit the pool of arbitrators. And at the moment, if you look at the pool of arbitrators, it's simply not as diverse as we would wish it to be. And that's why it's so important to have new, young, diverse talents coming onto the arbitral tribunals.
Felix, but okay, so we understand your point on no disclosure, but isn't the arbitrator's duty of disclosure very connected to what the parties actually reveal or inform in an arbitration proceeding? And in this sense, this connection between what the parties inform and what the arbitrator may disclose, doesn't that create at least an indirect duty for the parties to disclose?
Well, Luíza, this is actually the one gray area where I entirely agree with you. An arbitrator can always disclose, I know that party, so but he doesn't know maybe there's a silent trust behind that, or the arbitration is it's a third party financing, or there's an insurance standing behind it. And the arbitrator happens to be the chairman of that insurance or an employee of the insurance. So yes, there is a party, a duty to disclosure from the side of the party to enable then the arbitrators to disclose truly the facts that affect their impartiality and independence. But it's really more informing than disclosing what are the relevant factors in this arbitration.
Okay.
But Luíza, thank you for the follow-up question. I think that was really, really important.
Yes. And actually, I don't know if you are familiar with the Fazon case, which is the one we've discussed earlier in Brazil, but there are some people who actually wonder if in that case, the party itself in the proceedings shouldn't have at least brought it up that the arbitrator was acting in another arbitration proceeding. So that's why we're getting to this point, this discussion in how far should the parties go in order to help, I mean, not help, but give the arbitrators and acting in a transparent mode in arbitration and lead to not leaving any grounds later on for annulment. Mauricio, would you like to make comments?
Yes, you've touched on a very important point, Luíza, regarding the not only the candidate's duty to disclose, but also the party's burden to disclose. I wouldn't call duty, because duty, the failure to act according to that duty would lead to some sort of a liability, etc. The parties have a burden, or we expect as potential arbitrator some sort of assistance, decent assistance, help from the parties. What do I mean by that? The information, to disclose the information, proper information, so that the potential arbitrator can weigh in. So to be decent, to respect the level of playing field, and not to hide information to be used later in the ball game. So we all know that arbitration, and specifically the appointment of the arbitrator, is a strategic decision of the parties. But that is strategic cannot be cannot be to a point where the parties hide information in order to use if the outcome of the case goes against its interest. So I can see, and this is, Luíza, I would like also to hear your comments based on the CCBC perspective, because what I can see around the world is some institutions, they ask parties to provide information regarding third-party funding and subsidiaries, affiliates, the list of affiliates, and potential witnesses, a list of potential witnesses. So a huge list of information so that the arbitrator, the potential arbitrator, can diligently check whether there is any justifiable circumstances that should be disclosed or not. So I think that just to summarize, we very much focus on the duty to disclose of the arbitrator. That's fine. That's absolutely fine and necessary. But he or she is not the only player in this equation. So what can be done by the parties? What can be done by the arbitral institutions? What can be done by all involved in this adjudicatory proceedings to avoid what none wants to see at the end of the day, an award being challenged? Because this cannot be, when the parties agree to set up an arbitration clause, this cannot be the intention. So how can all players work on the same direction? So that said, I like the idea of receiving a list of potential affiliates, subsidiaries, and even potential witnesses, key witnesses, CEOs, CFOs, COOs that can help an analysis. I know this is not commonly used around the world, but I would like to hear what CCBC's approach on this issue is, if I may ask, Luíza.
Yes, certainly, Mauricio. Just before answering your very important, interesting questions, I will share my institutional perspective. I was wondering if Adriana would have any further comments or questions.
So thank you, Luíza. Yes, under the Brazilian law perspective, there is no an explicit duty or burden, as Mauricio said, for parties to disclose or to inform the arbitrator. So under Brazilian law, the arbitrator will disclose the facts that he knows or he or she knows that may raise doubts about her impartiality. So I think under Brazilian perspective, the party have the burden to inform the arbitrators facts, circumstances that may create or may show that may create a conflict of interest between the party and the arbitrator. For example, nowadays in my practice, I have seen that that parties also inform the arbitrator the affiliates or the related companies or circumstances and other facts, so the arbitrator can feel comfortable to disclose if there is another or any conflict of interest with that party. Thank you.
Thank you. Okay, so now going to from the institutional perspective. First of all, let me start by stating that, in my opinion, the institution's role is to provide the tools necessary, so needed for arbitrators to disclose properly, while at the same time providing these tools for parties, to parties for assessing the information being disclosed by the arbitrators. So this balance between providing these tools to the arbitrator and providing the tools for the parties, I think that that's where the institution can actually contribute in order to avoid possible misinformation, miscommunication, or lack of disclosure. And that is because the institution can only provide these tools. I mean, the act of disclosing itself is strictly the arbitrator's responsibility. Even if all arbitration proceedings were not confidential, there will still be information that only the arbitrator himself or herself could actually bring to the table in the discussions. In the case of the CAM-CCBC, regarding the specific points that Mauricio mentioned, we have the questionnaire, so the questionnaire on the conflict of interest, and that is the opportunity where when the arbitrator is led by reading the code of ethics and by reading the information early given by the parties in the proceedings, and then answer with their own disclosure of situations or relationships it may have with either the parties or the lawyers. And that questionnaire specifically sets a period, a parameter period, which is of the past 3 years. I know that in the past it was not strictly set the time, and now more recently it's being considered 3 years. The matter with the parties connected and affiliated, that is something that the institution asked the party from the very beginning. And so whenever the parties are invited to nominate or appoint their own arbitrators, they are asked to provide that information. If there are more parties affiliated or somehow connected to the dispute, which would necessarily be then forward to the arbitrator, so that the arbitrator may also take that into account when answering and when properly disclosing any kind of relationship they may have. On the point of third-party funding, we currently have an administrative resolution which highly recommends the parties informing third-party funding in the first opportunity possible. So whether that is in the early beginning, at the request for arbitration or the answer to the request for arbitration, or afterwards, as soon as it comes up, that the party does inform that, and the arbitrators naturally take that information and do the necessary disclosures connected to that. We are in the process of drafting a new arbitration rules at the CAM-CCBC, and that is something that is being taken into account, specifically the information from the parties and also the recommendation to inform the third-party funding. So it is possible that in the future we will have I think much like the ICC or some of the other institutions have recently moved in that direction, we will probably tend to require the parties to actually inform third-party funding instead of just recommending, because it is something that we noticed that in arbitration cases is being more frequently demanded from both the counsel and arbitrators. And last but not least, regarding Mauricio's comments, witnesses. No, we do not have any instrument, and we do not have that in the questionnaire, a reference as to potential witnesses in the case. And the reason for that is actually very, very simple, is because we believe that it's very early on in the proceedings when the arbitrators receive the questionnaire. And by then, procedurally, the parties will probably not even have this list of potential witnesses. So we do not have any provision specifically regarding potential witnesses. I think that answers Mauricio's questions.
Sorry for interrupting you. Sorry for interrupting you, Luíza. This perhaps comes from another difference in the international setting. For a common law lawyer, a CEO is a witness. A CEO, the owner, is a witness. And more than that, is a key witness. So this is why here in the United States, specifically in more domestic cases and some international cases as well, depending on the institution. So we, as potential arbitrators, we receive a list of, quote, potential witnesses. And among those potential witnesses are basically those who run the show, those who are involved in the agreement, etc. So it is something just to think about it. But again, this is because of these people, they are witnesses. And under Brazilian law, they are not so much.
Yeah, I understand that. And I think that's a very good point, Mauricio. But in your case specifically, so in your example, I believe that if this person would be highly likely that this person will be a witness, then it is probably a highly connected to the case, so highly affiliated. And that is something that the party may take into consideration when informing early on in the proceedings as one of the physical persons that are well connected to the case. And that means that the arbitrators will receive that information when they get the questionnaire to answer. And so you avoid that coming during the proceedings if you just, from the top, you inform it right away.
Yeah, and it's not mandatory. It's not a mandatory. It is just if the parties do not disclose anyone, that is not a problem per se. It's just an additional step, an additional assistance to potential arbitrator.
Yes, it's also a cautionary measure, so yeah, it may help in the future. Well, okay, so moving on to the final round, and that is regarding publicly available information. So we've mentioned in our previous discussion the disclosure paranoia, the difference between more experienced and more recent arbitrators. The ones who also Adriana mentioned that more experienced arbitrators tend to get more relationship with the parties as they move on in their career. So I was wondering, is the disclosure of publicly available information required? And what is to be generally considered public information? And third, what should be considered reasonable for parties to consult when performing their investigation? So, Felix, would you like to start?
Yes, I'm very happy to start with the German perspective. In Germany, there are actually no court decisions who address that topic yet. But it's very interesting and a wide range. And I'd actually like to start with your second question. So what is publicly available information? Because if you look at the internet nowadays, nearly everything is publicly available. Germany is in that sense a little bit special because in court decisions, all the party names, if the court decision gets published, are anonymized. So you don't know it's only party X against party Y with arbitrator 1, arbitrator 2, and arbitrator 3. And that's all the information that are publicly available. So I think it's advisable for any party when they embark on arbitration to research and find out as much as they can regarding a potential arbitrator. But in general, because some media, for example, GAR is actually a pay subscription, so it's not publicly available. The same with International Arbitration Reporter. Even Arbitrator Intelligence now has some information that's only available once you have a subscription. So I would say, in general, publicly available should be only anything that's available in the sense without a subscription. But it depends on the party. If you have experienced arbitration counsel on the other side, they have the relevant subscriptions, so publicly available information for them might be different than for an inexperienced party with a counsel who does their first arbitration. So having said that, I'm generally an advocate for disclosure. So I would also include publicly available information into the disclosure, in particular if they're crucially important to the case. It would be not serving the purpose of disclosure if you only disclose what's not publicly available, but basically leave out the most important facts simply because they're publicly available information somewhere on the internet. So yeah, that's my personal opinion on that issue.
Mauricio or Adriana, would you like to make questions? I have a follow-up question.
Basically, well, I am not very comfortable with this this notion of investigation. I think that the role of the arbitrator, or the duty of the arbitrator, is to disclose what he or she thinks it is important to disclose based on what he has received, the material he has received, the parties involved, etc. Once he or she goes to a sort of investigative process to go deeper, especially when we talk about public, and the question, your question, Luiz, is publicly available information. I understand and I applaud Felix's concerns that even those information the arbitrator, the potential arbitrator, should disclose depending on the relevance of the case or for the case. Well, sometimes we do not know exactly how relevant is for the case. If we do know, by all means, it doesn't hurt to disclose. But again, if this is available information, I wonder why such information cannot be accessed timely by the parties as well. So to me, publicly available information is public. Therefore, it's not something that concerns me in terms of disclosed or not.
Okay, so before we move on, we have a couple of questions from the audience. I would just like to make one final remark. Do you think that databases such as Arbitrator Intelligence, Jus Mundi, Kluwer Arbitration Practice Plus, and as very well put by Felix, those are not freely available platforms. But do you think that those, which provide for enhanced transparency of non-confidential information, could this type of information help in the near future or in the long run mitigate parties' expectations on arbitrators' disclosure? What do you think?
Well, I don't think those tools are very useful for parties. But again, the duty to disclose is an arbitrator duty. So I don't think that those platforms will mitigate the expectation of the parties related to the arbitration disclosure, because maybe those tools could help parties to know more about the arbitrators and to get more information about the professional life of the candidate to be an arbitrator. But at the end of the day, the duty of to disclose, the duty of disclosure is an arbitrator duty. So I think that still thinking under Brazilian law, the arbitrator has the duty to disclose any fact that he thinks that may raise a doubt or a concern on her impartiality. So at the end of the day, it's the duty of disclosure is it's an arbitrator duty.
Thank you, Adriana. So now moving to a question from the audience because our time is running up. Stephanie Arcangelo asked, what is your opinion regarding the limit of disclosure for third-party funding? And to what extent should the financed party disclose the financing situation to the other party? Mauricio, Felix, would you like to answer that?
Well, I think you have already answered, Luíza, that question.
From our perspective.
Yes. So, and that issue, the arbitrator, the potential arbitrator, relies on the information that is provided by the parties and with the help, with assistance of the arbitral institution, which I think is a great idea.
Okay, and final question is from Carlos Elias. I would like to address that one to Felix, because he would potentially have a different take for us as a German practitioner. So Carlos Elias asked, the usages of legal opinion here in Brazil, so-called pareceres, is very common in Brazilian arbitration. And do you believe that legal opinions should be revealed when they were given to counsel or office for one of the parties? Or following that, he asked if the institutions should maybe consider inserting that specific question in their standard questionnaires.
Well, Luíza, thank you very much for giving that question to me. I think the last question goes really to you as the representative of the institution. But giving a legal opinion is, in my opinion, a business relationship. You get paid for it, I assume. So that's something you would have to disclose as an arbitrator if you worked for one of the parties in the past, or you're currently working for a party in the past. And in particular, if that legal opinion refers to the case in question that you're supposed to decide, or even I would say it might not refer to the case in question, but it might refer to a legal argument that's very relevant in the case. For example, a party asks you to give a legal opinion on the interpretation of a certain contract clause, and that exact contract clause is then the center point of the arbitration. I think that should be disclosed, yes.
Thank you, Felix. But what about if it's not related to the dispute itself? I mean, the simple fact that arbitrator usually, so it would be sort of an indirect multiple appointment. So the fact that the counsel or party normally resorts to that arbitrator for legal opinions and is now appointing that arbitrator to act in those specific arbitration proceedings, do you think that might create an appearance of bias, appearance of partiality? Does that fall into the multiple appointment category as well?
Well, I don't think it falls within the multiple appointment category, but it falls, if the arbitrator is paid for his legal opinion, in the previous business relationship category. And under that category, it should be looked at whether it's substantial or not, and the arbitrator should disclose it.
Yes. Usually they are paid for it, and they are highly paid for it. So thank you for that. I agree, it would somehow fall into some sort of, depending of the amount of opinions that are given, it may definitely create an appearance that there is a financial relationship between those two. And since you gave the question back to me on whether the institutions should consider inserting that into their questionnaires, I will just use Felix's opinion on this, since he is the third neutral looking at the Brazilian arbitration practice. And since that is something that it would normally be disclosed and revealed, I believe that we should definitely include that question and then lead, because including that question, answering that question is not in itself a reason for parties to reject that arbitrator. But if they are entitled to know that, then that is something that should be disclosed early on. With that, I conclude, and thank you so much. It's been a very interesting discussion. Lauro, if you could have the floor.
Okay. Thank you, Mauricio, Adriana, Felix. Special thanks for Luíza. It was a great conduction. Thank you for Roseli Costa to put all together. And I hope to see you soon in the arbitration channel. And see you later. Bye-bye.